Hello, everybody. If there's anybody out there, it's Monday, the 24th of February, 2025, and we're all here again for the Housing Law live stream. And hello, everybody. And I haven't got a lot to, I must confess, I'm really tired tonight, so apologies. But maybe I'll get more energy as we go along. There was a couple of things I had on the agenda to talk about. But if anybody has got any questions, then please feel free to raise them in the comments, and we'll put them on the screen and try and answer them. So what I'll do is, for the last few weeks, I have been talking about trying to read a judgment, which I finally did read, which is called, hang on, I'll just go to this screen, that one. Yeah, it's called well, it's a judicial review, so it's called The King on the Application of Sean Ivory versus Welling Hatfield Borough Council. So it's probably just best known as the Ivory and Welling Hatfield. And what this case concerned, which is quite interesting, is repeat homeless applications. And when it is that a council can say, no, we're not going to process your application. Because on the face of it, every time somebody goes to the council and makes a homelessness application, Section 184 or Section 183 kicks in, and they have to process the application. And once they've started processing it, they then have to issue a decision at the end of it to close it down, as it were. And that's the Section 184 notice. And if they issue a Section 184 notice, then that has to set out entitlement to a review. And you can see it goes on, and the council may be saying, oh, we just found this person intentionally homeless, and they're back again. We don't want to go through. We've just been through a review and an appeal, and we don't want to go through all that. So what we'll do is we'll just say, sorry, we're not going to process this application because we've already told you we don't owe you a duty. And this is quite a common problem, and it comes up in a number of ways. One is if somebody refuses an offer of accommodation, the council will normally say to them, we've treated your refusal as unreasonable, or as an unreasonable refusal of suitable accommodation, and therefore we're treating our duties as discharged, and we're going to terminate your temporary accommodation and evict you. Now, what they really mean by that, if they, without thinking about it, is they're sort of saying it's game over. You've lost it. We don't have to do anything more for you. And my view is they're wrong on that, because if somebody is in priority need and they refuse an offer, I mean, common sense says if somebody's got children or they're vulnerable, they shouldn't be on the streets. So you can't just do the starting point of, oh, you refused an offer, so you forfeited all your rights. And so what should happen is that they should say, do we still owe you a duty for any reason? And if the answer, if they say, no, you're intentionally homeless, we don't owe you a main duty at all, they then have to think about whether this secondary duty under Section 190 applies, and they have to provide assistance, a bit like the relief duty, and then they can provide temporary accommodation while they do that. But if the council says, no, we're not going to do anything, then they don't get the right to their Section 190 assistance, because that's only triggered if you're intentionally homeless, and you can't be intentionally homeless if they won't process your application. So I've got a big judicial review going on at the moment against Ealing Council. I think I can name them, but I won't name my client, obviously, where she refused an offer of accommodation, and she went back to them when the bailiff's warrant, or after the bailiff's warrant was issued, and said, I'd like to be given temporary accommodation. And they said, no, we've told you we're not going to help you. So we haven't finished the case yet, but the council have been ordered to give her temporary accommodation while they look into her case. And I don't want to tempt fate, but I think we should win that one. So what they were thinking about in the Sean Ivory case is when it is, if ever, that a council can just say, no, we're not going to help you. And the answer, although this judgment, and the reason it's taken me a long time, I'm just scrolling down, you'll see there's quite a lot there. And if it was printed, it goes on for 30 pages. or slightly more, I think. So it's a long, long judgment, and it's good. It has a history of the case and all the relevant law. But Toby Van Hagen, who's barrister for the leading barrister, I think, for Ms. Ivory, comes up with a good expression, which I think you should bear in mind. I'll see if I can find it here. Spot the difference, he says. Yeah, there it is. So if I just clarify what the legal position is, if somebody applies, then the council will be entitled to say no. If, for instance, they've just been found intentionally homeless, and forget about all the stuff about refusing an offer, they just found them intentionally homeless or not in priority need, and the day they get the Section 184 notice, they're down at the council making a fresh application, and the facts of the application are absolutely identical. There's no change. In that situation, the council could say, no, we've just given you a negative decision. That's your lot. But what Toby says here is that you should actually sort of play a game of spot the difference between the facts when the person first applied or when the first decision was made and what their situation is now. And if there is a difference that you can spot, then they should process a fresh application. That's the simplest way to put it. And so if, for instance, you came up with some fanciful facts, fanciful is a bit of a strange word there, but it means sort of completely irrelevant. So if you said, well, the facts in my case are different now because somebody's number one in the charts who was different from when I applied before, that's got nothing to do with it. So that wouldn't trigger it. So essentially, you might have a situation, say, where your child has gone to a different school, you maybe have had a different medical diagnosis. It doesn't have to be a major change of circumstances, which is what you'd need in order to to break the chain of intentional homelessness. If you were going back and saying, you said I was intentionally homeless, well, I'm not anymore. You'd normally have to show that you'd had settled accommodation and lost that through no fault of your own. But here, you're not doing that. You're just saying, I'm back again and my circumstances are different. So the client who refuses an offer of accommodation and then comes back when they've been evicted from the temporary, to my mind, would be entitled to say, my circumstances are different because I've now been evicted from my temporary, which hadn't happened before. And that should be enough, I think, especially when Parliament has meant that the rights that she has to assistance can only be triggered following that fresh application. Does that make sense? I'm sorry if it's sort of waffly and I may have sort of driven your concentration away.
I'm still
But
following it. So I'm trying to remember the case. I think it's called like Fahia v Harrow or something, where there
yeah,
was a case
yeah,
where they were in temporary accommodation, then that ended, but they remained in the B&B for a year, and then they reapproached, and that was saying to
yeah,
be, even though there was
you're
kind of
right.
non-stop
That is one of the
accommodation.
cases that they talked about. Fahia. In fact, Fahia
That's
is mentioned, I think, 26 times in this case. And so
oh,
there's an
okay.
analysis of the judgment in that case. Um, and that's one where they actually said this to start with, that the approach, yeah, an application based on exactly the same facts isn't a valid application. But they said, the House of Lords said it has to be, you're almost always going to have to treat it as a fresh application because the facts won't be the same. And the problem for the council is that if they start making inquiries and they say, we've made some inquiries and we're satisfied that there aren't any differences, almost the fact that they had to make the inquiries proves that they're wrong. And the House of Lords said those are what's called, I think it was in this case or the next one, that you can't make extra statutory inquiries. You're either making Section 184 inquiries or you're not doing it at all. You can't have it both ways. So yeah, Fire was a major case on that one. And then there was another one called Rika Begum, where the same sort of thing happened. And so the long and the short of it is, if it's taken me a long time to read this, and I wouldn't expect most people to do it, and there is a summary of it on the Nearly Legal page. Sorry, I'll just go back. I think I can go. So if you want a simple summary, well, not
So
that simple. It's on here.
Sorry, Shannon. Yeah, go on, Shannon. Sorry, I was gonna say something then.
no, I was just going to jump in. So I've only read the nearly legal summary, and I won't pretend like I have fully sort of digested everything. But I think my main takeaway was the interesting stuff that was said around actually what's a fact and what's evidence. Because previously in casework, I'm not sure if I would have distinguished between the two necessarily, and I would have just gone, oh no, here's more new evidence, but probably based on the same fact, and actually them saying, well, no, it needs to be like they were saying this is not, it is evidence, but then they said actually it's because of the fact wasn't included in the first place, then that's why it's a fact, not just evidence. Whereas the council was saying, no, this is evidence. And that sort of like distinguish like difference really helped me actually understand, right, okay, you can't just necessarily build more evidence, it has to be a new fact. And I know that's that it was really pernickety when I read it, and I thought, I'm not gonna lie, in my head I thought, bloody lawyers, like,
That's what I
really,
thought.
facts and evidence, you kid, like what? But it does make sense once you sort of like get your head around it a little bit. But that was interesting to me.
Yeah, I mean, if I could expand on that slightly, because you're right, you've hit on one of the sort of crazy things about this judgment, which makes it quite hard to follow because it sort of defies common sense. But it's not just bloody lawyers, and it is lawyers are at fault here, but also it's housing officers because it's a bit like the Section 188 duty. If you take a really simple piece of English language which says that if you have reason to believe that somebody's in priority need, you have a mandatory duty to house them. And the emphasis being on reason to believe, not that you are fully satisfied. But how many times have we heard housing officers saying, oh no, we've got to carry out a full assessment before we can decide whether we've got reason to believe? And that's
And
because
make
there's so,
the
yeah, sorry, go on.
sorry, no, go on.
You, no, please.
I was just going to say, but and when housing officers make their own decisions on things, I think that was something that I took away from the Nearly Legal blog of actually saying, no, this person has had a full, 100-minute assessment. The housing officer's opinion isn't sort of above that, even though the case was, or the incident was like 8 years or however many years prior. And they were saying, well, the psychotherapist, whoever it was that did the assessment, um, didn't see it till years after. Well, actually, it was quite reassuring that it was sort of, my brain is not working today, guys.
Well, this
That it was
stuff is quite hard.
reassured that
It's
the
your brain gets bogged
professional,
down.
yeah, that the professional is the professional in this situation, not the housing officer.
That's another point. But the so to go to, so the starting point is you get a housing officer who won't back down because normally you take the housing officer aside and say, look, the test is actually quite different. You don't have to be satisfied they're in priority need. You've just got to be satisfied. You think you've got reason to believe, and the fact that you think an assessment is necessary means you've got reason to believe. Because if I came in and said, "Hello, everybody, I've got no medical problems, nothing wrong with me, but I'd like you to consider whether I'm in priority need," they might get away with saying, "Well, you just told us you haven't got any medical conditions, so we don't have reason to believe." But if I said I've got some medical conditions, they can't say, "Well, we haven't assessed you," because I've told them. And I think that's enough. But with this one, sorry, but then what happens is after a housing officer's made a sort of stubborn decision, no, I'm not backing down, the lawyer is then deployed to try to argue their way out of it. And so they'll do that by changing the meaning of words so that, they'll try and argue that somehow reason to believe means fully satisfied. And what you've got in this case in Ivory is the same thing happening. The housing office has obviously made a decision. No, we're not going to help this person. We're fed up with them. We've just had a year and a half of reviews and appeals and what have you, and now they're back again. What a cheek! And we're not going to do anything. And then the lawyers may have said to them in confidence in their advisory role, "Look, you really should process this." And if you think about it, all they've got to do is process it and find them intentionally homeless, and then they can do a very quick review and they won't be able to challenge it. But no, they won't back down. So they get a lawyer in, or lawyers, who will try and argue those things like this: a psychiatrist's report isn't a fact, it's just somebody's opinion of a fact. And you could say the fact that this is where it starts getting a bit silly. You know, that thing where you talk about there are things that are known and there are things that are not known, and there are things that between them. But here, you've got, if somebody's got a psychiatrist report, I would say, and it's positive, there's two facts there, isn't there? There's one, that you've actually got a psychiatrist report, which is a new development. And the second is that the psychiatrist report has pointed out something that the council weren't aware of. But then they'll say, no, that's just somebody else's view. And anyway, and as you say, in this case, they were trying to argue, well, the psychiatrist hasn't got the power to know what somebody's condition was 8 years ago, which they can do because they can analyse the medical records. And if somebody's got a long-term condition, which they can see they were diagnosed with when they were 10, they can probably take a good guess that if they've still got it at 30, they had it when they were 20. But anyway, the moral of the story, I think, is don't be put off by all the sort of dust that lawyers throw up in the air, because the courts are quite strict here and say, no, really, unless somebody's taking the mickey, and they really have just, or they've come back the next day from getting the negative decision and there's no change, then they've got to process a fresh application. So it took me weeks to get to that stage. Can I just say hello to some of our we got some comments here. So
There's a question in there, Will, that sort of relates to what we're talking about a little bit.
Yeah, I'll come back to hang on a sec. If I come back to here, I should be able to just go through these. We got DC. Hello to you, DC. And we got I would reply from Homeless Best Practice. Hello, that's William Flack. Sorry, did I? Oh yes, sorry, just saying hello. Sorry, it's sort of quoting me at the beginning there. So hello to you, Tiff. And just to go back, so here we've got a question from Anthony. When presenting evidence for a housing request, should case law help the request? By request, do I think you mean, well, either you mean a housing application or a review? Maybe you can clarify that, Anthony. But I mean, I was just discussing this the other day with Karis, actually. We were talking about the extent when you're making representations, you want to start quoting case law. And my view is that probably you don't really need to, unless it's a really obvious case. So, for instance, if you were doing a case where there's just been some big case in the news, housing news, as it were, then you might mention it. But I think I would just mention the issue involved in the case rather than the case itself. Otherwise, you get stuck because you end up doing masses of research to find out all the relevant cases, which you don't really need to do. I mean, I think the code of guidance is the best place to go when doing review requests and applications, because that really does set out a lot of detail and it refers to the statutes. And
I think
go on.
No, go on.
Correct me. No, please.
No, I was gonna say, I think it's something I like not struggled with when I was a caseworker, but actually it's a fine balance between, if you go in and make a homeless application and you say, I think I'm priority need because of X, Y, and Z, here's the code of guidance, here's case law or whatever, right in that initial email, then, and it's a bit different as a caseworker, but like say as an individual doing it, you can really get a housing officer's back up, and actually like you're kind of fighting against egos then, and all right, you could be 100% right in what you're saying, but by going in like with like case law and everything else, and occasionally actually you can kind of dig yourself a hole, because then they kind of go, well, why does this layperson think they know, but why are they telling me how to do my job? Which
Definitely.
in fairness likes being told how to do their job, right? But so I think there is a balance between, like for me, I would just present the facts really, really clearly when making a homelessness application, everything in writing, and I would be sort of armed with my toolkit of case law if needed later down the line. And again, if it was just me doing it for myself and not on behalf of a client, I would again be quite non-confrontational in my approach and be like, my understanding is this. Could you confirm whether I'm correct in this or whatever? Because if you know you're right and they go, oh, no, you're wrong, it's only helping your case later down the line if you get a lawyer involved or if you're making a complaint or whatever it might be. But B, actually, by sort of playing your knowledge down a little bit, you're sort of giving them the opportunity to do a really good job and go, oh yes, no, you are right. I'd forgotten about that, really obvious bit of case law. That means you're in priority need or whatever it might be. So yeah, I think it's definitely helpful to have the case law and to have like code of guidance quotes and stuff, and sort of you can, it's a bit weird, isn't it, guys? But I think we can all predict what the problems or the potential gatekeeping for each scenario could be. Like, if it's a single man with no kids, you can kind of see where the council might go. If it's a family who's being evicted, you can kind of see what, where the council might pick holes in the process. So I think it's just arming yourself with the information and then presenting it when needed rather than right at the beginning. But what does other people think? Sorry, because I rambled there.
I would agree. Like if you go in and like you say, tell them how to do their job, you're going to get someone that's going to be gunning for you, and also they will try and use it against you. So they'll be like, well, that's not relevant, and then you'll trip you up. So if don't have the knowledge of it, they'll interpret it in a way, and you'll get pulled into this whirlwind that you can't defend yourself against, and you'll be thrown into it. So almost like, and I do call it, it's like a dogfight rather than actually sorting out the problem, which is you need to be housed, rather than be in the mud pit and talking about case law and stuff with someone who also doesn't understand the law and how to interpret it, and will also be having their egos chipped away at. So you'll get someone like that already has that power badge on them. So you'll get kind of dragged into this unnecessary fight when you've got so much more going on. So I do think it's unnecessary for at the start and at the beginning.
Yeah,
and that's why, like with vulnerable people, this case is kind of like there is like a concern that someone who is so vulnerable had to go to the lengths of getting a psychiatric report and go through 100-minute assessment. So what about people that don't have access to that assessment within such a time when they're at risk of homelessness or becoming street homelessness, but they've got to go through the process of getting a psychiatric report.
yeah,
So
yeah. So are we all agreed there's probably, I mean, by all means do mention the odd case if you want to, but don't feel obliged to. Um, for one thing, it'll mean that your reviews representations probably take you 10 times longer to prepare than otherwise, because you're going to have to start reading cases. And the problem with reading cases is that cases refer to other cases, and then you sort of end up going down sort of 5 rabbit holes, and suddenly it's 2 weeks later. Got a comment here from Dolov FM. I think it's more constructive to look at the bench book standards on equal treatment if you're self-repping, or have someone with you who can point out errors of bias if present. Yeah, that's true. Although obviously people, I suppose you can discreetly point it out, because I mean they will be biased because they're looking at it only from their point of view. And but if you call them biased, they'll sort of, how dare you suggest I'm biased? But they are. So yeah, if you're on your own, it's good to have somebody to support you on that. I've got another question before I move on to the next. Anthony's also asked, if a case goes to court, can you ask the judge if he or she are under their oath? Do they have to answer legally? Now, this is something, and what is the purpose of the oath? I don't know if anybody else like me watches as much YouTube as I do, but one of the things I quite enjoy watching is what's called sovereign citizens in America. There's more of them in America than I think they're called people of the, what is it called? Man of the land or something here that you call yourself. But are you familiar with sovereign citizens? In America, the basic, without going down too much detail, there's people on the internet encouraging other people to think that you can sort of abdicate from civil society. So like if you don't want to pay car tax or get a driving license, all you need to do is get some of these number plates you can get off the internet, and it says this car is not is exempt from all the laws. So when the police pull you over, you say, "Oh no, it's okay. They've got this weird thing. They say, I'm not driving a car. I'm travelling, and you can only do me for breach of the traffic laws if I'm engaged in commercial activity." It's complete nonsense, and it just sounds like they're on some sort of either narcotic or medication, which just makes them talk nonsense. But, and no disrespect to you, Anthony, but one of the questions that they tend to do, and I'm not sure if this is where you've heard it, because I tend to hear it when one of the things they do, although they pick fights with police officers about not giving their driving license when they're pulled over at the side of the road, which usually ends up with them getting taken away in cuffs, or worse in America, and they're tased and stuff. But they go to court and then they start asking the judge for details about the jurisdiction. And they start, believe it or not, they start talking about admiralty. Is this an admiralty case? And it's just a motoring offence. But one of the things they say to the judge is, are you complying with your oath of office? And I think in a sort of American way, this is that you should be representing the people and not the man, as it were, which doesn't really apply here because I don't know the judge. I suppose they do take an oath, but the only oath that really matters in our courts is the one where you're giving evidence as a witness. And so that doesn't really apply to the judge. Because if you ask a judge, are you complying with an oath, they may say to you, yes, I am, and that's the end of that. Or they'll say, that's got nothing to do with what we're talking about, and move on quickly. So but the purpose of an oath in the general sense is that it's what's known as a conditional self-curse, that you traditionally you're holding a Bible and making a statement to God that you're telling the truth, and the implication is that if you're not telling the truth, then God can hear you, and you're in trouble. Something bad's going to happen to you. But then once you've done that as well, you've got the problem that it's a criminal offence to give false evidence under oath. But none of that really applies to a judge. I've never heard of a case where a judge was criticised or pulled up in this country for doing something outside their oath. So I hope that answers your question. And just say hello.
I mean,
sorry.
That's kind of scary in itself, though. Like the fact that we've never heard of a judge that's not done something wrong makes me feel like that's not right. Like, because judges surely must I'm not like a bad mouthing judges, but surely there's no profession where 100% of people are kosher.
No.
Like
no, there's lots of cases where judges get into trouble for being naughty.
Right, okay, that's reassured me a bit. Thanks.
Or unprofessional. I mean, there's lots. If you read the history of cases on rape cases and sexual abuse cases, it's just chapter after chapter of judges making appalling comments, really dreadful comments, like saying that a child who'd been abused, it was very bad what the man did, but she was no angel herself, even though she was only 11. And, just mind-bogglingly bad things. And those judges do tend to get sacked. And there was one judge, for instance, who was trying, believe it or not, he was doing a case with British Airways, involving British Airways. This is only about a few years ago. And all through the case, he was going on and on about some grievance he had, that he'd been overcharged himself as a passenger. And eventually he got badly told off for that. So yeah, there's lots. And unfortunately, judges do tend to put their foot in it a lot. And they still need quite a lot of training, I think, to avoid doing that, because they have to sort of put on this mantle of being all-knowing, and that's often a recipe for disaster. So hello to you, B. Smith. Sorry, put your message there, and I'm glad your phone's back on again. And sorry, Dol, we've got that one from Dolov. Sorry, I meant the court rather than direct counsel. Yeah, I mean I think the problem, if you're going into court, ideally you need a lawyer. I mean, if you can get one and afford one, and you're eligible for legal aid, because the courts don't take very kindly to people sort of trying to help. You can, and in fact, they'll probably try and stop them. There's a thing called a Mackenzie friend, which is a role you can have in helping somebody at court. But the minute you start speaking for them, the judge will sort of probably shut it down and say, no, you're not an advocate, and I'm not hearing you.
And
So
don't you have to
beware
ask
of that.
permission with a Mackenzie friend if they can come in? And
Yeah, yeah. I think you can be appointed as a Mackenzie friend, and probably if somebody was disabled, let's say somebody was very hard of hearing or had limited vision, and somebody came to court and said they were going to sort of help, the judge would probably be very grateful for that. But once they start sort of arguing the person's corner, that's when the sympathy runs out. There was some cases, probably about 5 or 10 years ago. There was some people that were sort of being professional Mackenzie friends, and they were actually big lawyers. They were just calling it Mackenzie friend, and it was just a way of getting around the rules that say that you can't be an advocate for somebody unless you're qualified. And so there was cases of people getting into trouble for that, which is why you don't tend to hear about Mackenzie friends as much nowadays as you did a while ago. So, oh yeah, sorry, thank you. The term is freeman on the land, and yeah, it is a dangerous rabbit hole. You'll be pleased to know I haven't got seduced by any of the arguments yet. I think it is. I'm pretty immune to it so far. Now, Cheeseface is here. Hello, and Tiff's comment very well said about some judges. Yeah, I mean, I could go on. That is another dangerous rabbit hole for me to go down, because I'd probably start ranting and then I'd get pulled up before the Law Society or I'd be in contempt of court or something. But I could just tell you from my own experience. I mean, judges often behave in ways that mere mortals would be very embarrassed to behave in. But I suppose that's because we put this weight on their shoulders to be judges, and sometimes the weight is too much. So those are all the comments so far. But can I jump through to the second case I wanted to talk about? Unless anybody wants to go on. And this actually does tie in with something we were talking about earlier, which is, you may forget now, but with the first case, we were talking about putting facts or cases, or should you argue cases, yeah? And this case here, although it doesn't appear immediately to be about that, was about that. So this is an interesting case about intentional homelessness, but it was also about the question of, can you raise something at an appeal if you didn't raise it at the review stage? And the usual answer to that last question is yes, although the council will make a fuss, because what they'll say is the review, if you raise something at review, then the reviewing officer can deal with it. But if you only raise it at the appeal stage, it's not fair on the council. And that's true of facts, but not of legal arguments. So you can see where we are going with this. What's the difference between a fact and a legal argument? So what happens in this case is that this applicant was found, she got housed by the council, everything's fine and dandy, but then it turns out later on that the council discovered that she was already a council tenant somewhere else, which meant that she obtained her new property, which I think is council tenancy as well, by fraud. And so they took possession proceedings and evicted her from there. And then when she reapplied to the council, they did actually accept an application from her, and they found her intentionally homeless. And she requested a review, and they said at review, no, because you're intentionally homeless because your deliberate act, because remember, you've got to have a deliberate act which leads to you losing accommodation which was available to you and reasonable for you to continue to occupy. So your deliberate act was you provided false information, and that led to the loss of the accommodation. The property was reasonable for you to continue to occupy. So she then, at the appeal stage, they just deal with the issue of whether it was a mistake. I'd forgotten that I had a council tenancy or something like that, and she lost. But then at the appeal stage, she had the advantage of having, without wishing to sound too obsequious, Shadzia Nabi as her lawyer, who is up there, I'd say, in the top 5 housing lawyers in the country. And he, you would have thought he'd be onto a bit of a weak case because, I've gone to Ivory, sorry. You'd think he had a tough job on his hands because everybody would have it in for this person that was a fraud and a person taking council property by deception. I mean, it seems to be a sort of modern thing to treat these people a bit like they sort of started a war or something. But nevertheless, he fought it, and I think I've just got to go back to the actual decision. I think I'm on it here. So let's go back to the nearly legal coverage of it. So he said, he raised the legal point, which is that if you had no right to occupy a property because you got it by deception, and it was inevitable you were going to be evicted once they found out, then it wasn't available for you to continue to occupy. So that final bit of the test wasn't made out. So the council said, that's not fair. You never raised that at the review stage, so we didn't deal with it. The judge thought about it and said, well, if she didn't actually raise a fact appeal, which she didn't raise before, she just raised a legal argument, and she doesn't have to raise all the legal arguments at the review stage because the reviewing officer is supposed to understand the law. So if the reviewing officer, on looking at the facts, makes an error of law, it's no excuse to say, oh, well, it's your fault. I made an error of law. I got the law wrong because you didn't tell me what the right law was. And so she won her appeal. Unfortunately, they'll probably come up with a way around that. But it was
I've not read this in any detail, but shouldn't the test therefore be, so that wasn't settled accommodation, if I understand it correct, the one she obtained by deception wasn't settled. So shouldn't they therefore go back to the previous property she was in and say the act of leaving that accommodation to move into the fraudulent one, was that not kind of her giving up settled accommodation for unsettled accommodation? Is that not how you'd run it?
It could have been, but the problem is if she left that previous accommodation in circumstances which were legitimate and she was genuinely homeless, for instance, if her previous landlord, if she was living in a private place and she just happened to have a council flat that was in her name, but she lost her private place through the landlord wanted it back, the reason she became homeless wasn't that. But if we look at this is the case, the main authority for this is an earlier case called Chishimba v Kensington and Chelsea in 2013, and where they said there, where an applicant obtains a tenancy of property by deception and was not eligible for that accommodation from the start, it cannot be said the applicant has accommodation that was reasonable for them to continue to occupy, which is, you may say, we just said that, that's the point you just made. So I guess it would be open for the council to say, well, okay, we can't treat the place you got evicted from as settled accommodation or accommodation that was available to you, but we can treat the one before. And if that, and you'd be right, that's what they'd have. I think that's the only way around it. Otherwise,
because I got the impression, I mean, as I said, what I picked up from it was that effectively she had one tenancy which was fine, and then she got this other tenancy in a different district by fraud, and then moved into that, but in effectively gave up the other property. I need to read it again probably. I mean, it leads on to a question I've actually got to sort of add in on this topic if you've got time, Will. Which
far away.
Well, so I mean, okay, so sounds like a bit of a tangent, but I'm going to bring it back into it. So I did a video 10 days ago, which was about minded two letters, and in the video I basically said that you want to keep one piece of information up your sleeve. Just so, let me go back a step even further. At the section just before the Section 184 decision has been reached, some councils will issue a minded two letter at that stage, sort of saying, "What else have you got?" And so in the video, I kind of said, "Well, you should hang back at least one bit of information, which is more than trivial." Because if they then proceed and make a negative decision, you've then got another bit of information which you can use to request temporary accommodation and get temporary accommodation. So let's say you've got a doctor's report, a psychiatrist's report, and an OT report. You provide two of them at that stage, then they proceed to make a negative decision. Well, then you've got that one remaining bit of evidence to be the new bit of evidence to kind of request a accommodation master review takes place. Hoping you're following me so far. And I've got a few comments kind of saying, wouldn't that be unlawful? Wouldn't that be a criminal offence in terms of withholding evidence in accordance with Section 214? And I don't think it is, but I could be wrong. So I've pulled the video for the time being. But I just wondered this kind of idea of new information coming, in one sense deliberately. So a bit like in the Ivory case, where let's say it didn't quite happen this way because they didn't submit the psychiatrist report in the Section 284 stage because they said they weren't supposed to. They're not supposed to provide new evidence at that stage. But that kind of idea of strategically withholding bits of information so that you can then make a fresh application or ask for review and get accommodation is kind of, I don't know, would that, the way I read section 214, I'd say, I don't think it's certainly not what the intention is of section 214. I think that's more about changing circumstances where, for example, like some say a pregnant woman moves out of your household or something, so you lose a priority need, but you don't tell the council. So yeah, so I don't know, like, if that question makes sense and if you have an
No, it
answer to
does. It does. Hang on a sec. I'll just. I've got this comment back on it. I'll just get the comment out of the way. I'll just have a look at section 2 because there's a couple of different issues in there, aren't there? Sorry, I'll just get. Is it that one that I need to get?
Yeah, I'm just looking at the wording of 214 now.
Yeah, there we go. So 214 is just for everyone's benefit. Section 214 is a scary section that council sometimes remind people of, which is that it's a criminal offence, isn't it, to give false information or withholding information and a failure to disclose change of circumstances. So, yeah, I don't think. Well,
because the key thing is it's to induce them to think that, essentially, if I paraphrase it, is to withhold evidence or kind of falsify evidence to induce the authority to effectively believe there is a duty to house you when there isn't. But that's not exactly the same situation as what I'm talking about, because you're not kind of falsely showing that there's a duty to house you when there isn't. There is actually a duty to house you. You're just trying to
yeah,
play
I don't
the
think what
system
you're
to safeguard
describing
yourself.
comes within 214. Whereas it would come within 214 if I applied to the council and I withheld the information that I have a council tenancy somewhere else, yeah?
Yeah.
Because that's something that they would read. I would be expected to tell them. But what you're saying is different. That you've got some piece of information that might make a difference to a review, but you keep it up your sleeve, and somebody might try and argue that that's a breach of its information that you've withheld that they were reasonably expected to require. But you haven't done it to induce them to believe that they should exercise their functions. In a way, you've done the opposite. You've kept it up your sleeve in case they make a negative decision, and then you can make a fresh application later.
Yeah. And I guess there's a subsection 3. A person who fails to comply with subsection 2 commits an offence unless he shows that he was not given the sorry, not that one, the one before it. So it's where there's basically where there's a reasonable, where's it gone? No, that's not the bit I was looking at. Essentially, where there's like a reason, either reasonable excuse for non-compliance.
It's B, I
I'd
think.
argue that's a reasonable
Knowingly
excuse.
withhold information which have reasonably required him to give. So yeah, you could. Well, they could say, I'm playing devil's advocate, but if I invite you to give me all the evidence why my Section 184 notice is invalid, I might reasonably be requiring you to give all your evidence that you've got. But what happened is, I don't think it would be that serious though, because you're not trying to trick anybody. You're just trying to sort of. The worst thing you could be accused of doing is just trying to trip someone up later on by withholding something now. Yeah.
So I'd argue that the burden lies upon the authority to make the inquiries, and the fact that councils used the minded to letter at the section 104 stage seems to me specifically so they can avoid the situation where they can say, oh, we've taken everything into account, you've got nothing else to now throw at us, so we don't have to accept a fresh application. Or so that's kind of, I think, I can't find any case law in it. I'll keep the video down unless I'm kind of confident I'm not advising people to break the law. I'll keep it down. But I just thought
there's a couple of problems you might have with that though. See that looking at it from the starting point where you're coming from, one of the problems of telling the council everything is that they'll just use that. They'll basically get all the evidence you've given and they'll list it in the 202 decision. We've considered this, and including the bit of evidence that you did give them, which you might have otherwise held back. And we've thought about it all very carefully and we've reached a decision. And we might even have a paragraph showing why we disagree with each piece. And then you get a judge saying, well, they've thought about everything and they've applied the law, so we can't do anything about that. So the holding something back might give you something to a nail to hang that on. But I think you might fall into difficulty because there's a case called Cramp v Hastings, which is the one that local authorities always rely on when somebody raises something at appeal that they don't raise at review, and to say in factual and say that wasn't raised, and so you can't rely on it. It's not a concrete rule. And the other one is, of course, what we were just talking about here, that they'll say that you're not allowed, you just can't raise it because, well, I suppose it's the same thing. You can't raise it to appeal because you didn't raise it at review. But you could, of course, make a fresh application and refer to that. But that's what happened in Hatfield. They were they were referring to stuff that was being talked about before, but I think they actually got the report during the appeal but didn't disclose it or something.
Yep.
But it can cause a lot of fighting. So, I mean, I'd have to say, without having seen your video, as a lawyer, I would have to say I couldn't advise anybody to hold anything back at the review stage, even tempting as it is to do so. What I would
is that different from the Section 184 stage? So I get what you're saying about the step between 204 and 202 and 204, but I'm saying at the initial homeless decision, the Section 184 decision, could someone get in trouble? I guess that's what I'm asking.
Well, I think they could, because they'll say you deliberately held this back. Which, if they were telling the truth, then they'd said, "Well, yeah, I did that because Mike's video said that was a good idea." So they say, "Well, you would holding something back." What I tend to like to do is maybe mention something, but don't go into mention it in passing, but don't go into huge detail about it. So they have it, but they ignore it, and then you can get them that way. Whereas if you spell it out for them, it's easier for them to sort of add it to their list of things they've thought carefully about when they haven't really at all.
Yep.
I think that was all I wanted to say about this intentional homelessness case. So yeah, the moral of the story there is, I think you can usually get away with raising things at appeal, especially if the person doing the review was a litigant in person and the person at the appeal was a lawyer. But if it was the same lawyer, as it often is with me, that's raising the stuff at appeal and didn't raise it at review, I'm often a bit embarrassed if I don't give everything. So we've got a couple more questions. Tiff says the Law Society, that was where I said I might get in trouble with the Law Society if I was criticising judges. And you're right, and they should be understanding, but the problem is they'll say, well, there's places, there's forums in which you can criticise judges as lawyers, but technically as a solicitor, I'm an officer of the court, and I have to respect the judge's position. So I can't sort of go on YouTube saying Mr. Justice so and so is sort of anti-Semitic or something, or it's I'll get in serious. Well, it might be libelous as well to say that, but you know what I mean. I would get into a lot of trouble if I did that. Possibly rightly, but I agree with you. Sometimes you've got to blow the whistle. And then we've got Anthony saying, sorry, I'm sorry if I suggested you were a sovereign citizen, Anthony. I inquired about the judge's oath because housing is heavily evolved laws. If an oath was implemented to the housing debt, maybe the housing office would be more. Yeah, I think again, when you say the judge's oath, I think you may be referring to the oath that the judge requires people to give when they're giving evidence, rather than the judge, because the evidence won't be affected one way or the other whether the judge has given an oath. But as you say, the housing officer would be in trouble if they gave evidence under oath. But one of the crazy things about the oath, if you think about it, it's a criminal offence to give false evidence under. It's called perjury. So if I go to court and I give an oath and I say, yeah, I was walking down the street the other day and I saw this happen, and it turns out I was the other side of the country, you'd think, well, that's a criminal offence. But you'd think that must happen in just about every case. There's usually somebody saying this happened and it didn't happen, and they knew it didn't happen. They were trying it on. But the only person I ever know that's got into trouble with this was Jeffrey Archer. Maybe many people are too young to remember that, but he went to court and lied about giving money. I think he'd been giving money to a prostitute or something, and it turned out he had. and he'd been lying about it, and he actually went to prison for it. Maybe because he was Jeffrey Archer, but that's the only time I've heard of it. And but we all know that you see housing officers or police officers. I hasten to add. I won't go too far down the rabbit hole, but police officers are well known to be very have a bad relationship with the truth, but they don't tend to get into trouble. But that's another story. So what I will say is, have we got time to quickly talk about the local government decision that I wanted to talk about? We've got 5-10 minutes. Are you guys okay for that? I'd recommend this to people. If you by the way, if you're wondering what I've been talking about, if you look in the details for this show on YouTube, it does give you links to the decisions that we've talked about, the things we've been talking about. So if you want to see those links to the things I've been putting on the browser, you can look in there and get it yourself. But I'll keep it short, this one, because you can read it. It's very nicely set out, as most Ombudsman's reports are. And what I will say is I'm going to try and have a sort of feature on an Ombudsman report at least every show if I can, because they're really nice ways of summarising the law and showing how it works. So in a nutshell, this one concerns the role of the duty of local government to protect people's belongings and store them when they're homeless. So if you're getting evicted from your home and the bailiffs are coming, it's not just about you that needs a new home, it's to stop the bailiffs or the landlord putting your stuff out on the street, which they can do after a while, and disposing of it. The council have a duty to help you. And that comes under section, where's it gone? Protection of belongings. Section 211, and have a look in the Homelessness Code of Guidance. That's probably the best place to start because it gives you a nice summary of it. But basically says where the council owes housing duties to an applicant, and that's our old friends under section 188 or 193, they must protect the applicant's personal property if there's a risk that it might be damaged or lost. And they can make a reasonable charge for that, which would have to be an affordable charge, obviously, and reserve the right to dispose of the property if it loses contact with the applicant. So we see where we're at there. So somebody's being made homeless and they ask the council for help with accommodation. It's very, very common for them to say, sorry, we can't do anything about that. Here's a list, there's a storage place down the road, go and ask them. So that happens here, and I won't go through all the facts, but I'll just cut to the end, where it found that the Ombudsman finds that Mr. X didn't get the help he was entitled to and had requested in storing his belongings, and therefore he had to pay for it himself. So the compensation that he was awarded amounted to, if we just go to findings, that he was entitled to, the agreed action, I think that's where we go, yeah. They had to apologise to him and pay him £300 to compensate him for the stress which he'd suffered. But significantly, they had to pay him £2,144.77 storage costs. So if you're stuck on that one, it's on my it's on the details bit here, but it's Portsmouth. If you were to Google, I don't know how easy it is to Google these, but if you did Portsmouth belongings and Ombudsman, you might come up with that.
If you search for that code, it comes up as well, Will. It will come straight up. So 23016, 20210.
I just found out, actually, if anyone has tried to go to my blog, there's something I'm going to have to spend a few hours trying to sort this, because I've got a critical error on the website. So you won't find anything on there at the moment. I've got to follow this and sort it. But you can find the stuff on YouTube here. So that's the end of that.
Very quickly, Will, as well. So that case, although it doesn't mention it, is actually talking about our old friend about the advice to stay until the bailiff comes. Because basically, there aren't many cases on the LGO website talking about it, but it does make that point that that this guy was homeless as soon as he told them that the possession order had been granted. He was already homeless. He should have been offered interim accommodation then, not been told to wait until later in the process.
Yeah, so I think it mentions it here in the findings, doesn't it? The Code of Guidance sets out that it's highly unlikely to be reasonable for an applicant to continue to occupy property beyond the date of a possession order. So the council failed to assess or document how it considered that it was appropriate in Mr. X's case, which of course is because there wasn't any consideration of that. Probably they just thought, oh well, let's tell him that because it's always seemed to work in the past. There's a couple of interesting questions we could maybe come back to for another day. I will give in to temptation, but if we go back to the rule on storage costs, go back here, the duty to store belongings, protection of belongings. This is interesting. Where the council owes or has owed certain housing duties. So that begs the question of, does that
It's
mean
relief
if,
duty as well.
I beg your pardon?
It's relief duty as well. So, and I guess technically
Yeah.
prevention duty, but I don't see how that would work. But yeah, so if you've ever been owed the relief duty, this protection of property duty will kick in.
But the question then is, and we can maybe think about this for another day, is how long does it last for? Because the wording here suggests that the relief duty could have ended, but the duty to store the belongings or protect the belongings continues. And
Yeah,
I
I
don't know
don't
the
know
answer to that question.
yeah, I don't know either, but it's designed specifically to catch that sort of thing. I guess until your period of homelessness has ended, is my guess. So that, yeah, and how that would work in reality, I've got no idea. But that's the way that chapter 20 of Code of Guidance sets it out.
And anyone who knows more about this, please do help me out with that one. And the other thing to remember, it's a common question that comes up, but maybe people listening or watching have forgotten about it. But the question is pets, and I think we've talked about this before, but pets comes within the definition of belongings, doesn't it, or personal property? Hard to think somehow of that, but so go on.
Yeah, just to say it does. So I kind of made this point that you can, if a council's saying that they can't house you with your dog or something, then you say, okay, well, I've got nowhere else to put it, so you're going to have to pay for kennel costs. And that's in Bedford. At that point is when they started actually finding housing for people with dogs, because they cost too much to do it otherwise. Which is why I dislike the Dogs Trust, because they very helpfully come in and say, oh, don't worry, guys, we'll take your dog, and then the council can get out of it. But if Dogs Trust didn't do that, then councils would have a much more difficult time working out what to do with pets.
Are the Dog Trust a national organisation? I mean, obviously,
I think so,
yeah, presumably they're not. But do they have kennel facilities all over the country, or is it just?
I don't know, but they kind of boast about, helping homeless people out by taking their pets, and it's like, you idiots, you just made it worse.
Yeah,
It,
agreed. And they are national, and they will. And there's quite a few other charities, not just the Dog Trust, that will sit and say, "Oh, we'll help house pets," instead of being like, "Oh, they should stay with their owner."
and
It's not a charitable thing.
what about cats? Are they? I think cats are personal property as well, are they?
Yeah. So on the live stream on Thursday, someone had an iguana in a 6-foot tank,
Yeah.
and as far as I can tell, that's property, both the tank and the iguana.
Yeah, I just remember there's a legal distinction, and forgive me if I'm going off the track, but a cat is a wild animal,
No, it's
and
vermin, I
and a
think.
dog is a domestic animal. And so the difference is that if my dog jumps into your garden and kills your rabbit, I can get sued. Whereas if my cat does it, I can't because he's a wild animal, which seems crazy, doesn't it? But I guess but it doesn't mean that a cat is a wild animal and therefore it's not property, because you could have you could have a pet snake, couldn't you? And nobody's saying that they're domestic. Well, not around here
I'm just
anyway.
googling. It seems they would be property, because if you think about it, you can steal cats, so therefore it says it's AI generated, but saying it comes under the Theft Act 1968.
So there we go. I'm glad that we, because I've often been really stuck, because you get somebody accommodation and then they say, "Oh, I can't go there without my dog," and you think, "Oh no, what can I do?" And I'm so exhausted trying to fight for them to get a
And
place.
actually, there's a new law that cats have to be microchipped to you, so they can't be wild anymore.
Yeah, maybe it's changed their status.
Yeah.
Well, maybe it's just that they may be wild, but that doesn't mean they can't be property and you can't be liable for. Because if I had a pet lion in the garden, nobody's going to say that's domestic, but I'm sure I'd get sued if it was causing damage to my neighbours.
I,
Anyway,
I
probably
have to say this, since you raised it, Will, you should Google how many like dangerous animals there are registered in the UK. There's loads of like lions and tigers and alligators and all sorts of, like, genuinely, it's Central Beds, which is like near us, has got like one of the highest in the country. There's like hundreds of them, like literally hundreds of people with lions apparently.
there is a case which I've forgotten what it was called. It's not Rylands and Fletcher, but when you're studying law, you have to. One of the things you study in tort law is how you can be liable for things that you cause which aren't contractual. So that, for instance, if I had a massive swimming pool, I built a swimming pool in my living room and it flooded out the flat below, I'd be liable because something escaped from my flat. But one of the original cases on that was somebody in Notting Hill Gate was actually running a zoo from their inside their house, and it had lions and bears, and something did escape from there and cause damage. But so let's just get the last of the comments, if I may. So I think that would be Tiff's question here. We haven't done. Are councils allowed to refuse to provide certain items to meet decent home standard that should have been put in when the property was emptied and so-called refurbished? Ooh, that's a bit of an open-ended question there, Tiff. If you're, I mean, I guess the answer, to go back to your main question, correct me, do jump in, guys, but if I'm not quite sure what the decent home standard is off the top of my head, so I can't tell you that, give you a shopping list of things that you need in order to meet it. But presumably, councils are not allowed to refuse to put a property into a condition which makes it unsuitable. That's sort of dodging the direct question, isn't it? But I suspect you're thinking of a particular case here, Tiff, which is factual, and it might be easier to answer it with reference to that. But I mean, the general proposition is, isn't it, that it has to be suitable. So they can't sort of say, well, and standards say that it should have this and this and this, but we're not going to bother. I think they'd get into trouble. And when I say not allowed, then you could challenge the suitability of the accommodation or apply as homeless on the basis that you're still homeless. I hope that answers that. We got. Would that apply to interim accommodation? I think, Cheeseface, your question, I think you were asking about whether the duty to store belongings was interim accommodation, unless it was the previous point that Tiff had raised. But the answer is yes, it applies to all of that, because interim accommodation has to be suitable, and interim accommodation is provided pursuant to a duty owed, so the duty to store belongings would kick in. And so somebody's answered that one already. Sorry. There we go. So that's your answer. And in fact, Cheesecake ignored that, so I didn't even need to go down that road, but I thought I would. So Tiff's got. And this might have to be. We got three quick questions from Tiff. Now I think we'll have to wind up. So, can councils enforce their contractors to not abide by the Equality and Disabilities Act when the tenants inform the contractors? No, I think I can stick my neck out there and say no, they can't force. I mean, councils can't or can't legally encourage people to breach the Equality Act, because that would be unlawful. And they also have a duty under under that act. There's a public sector equality duty, which means they have to consider the rights of disabled people when and enhancing their living standards or quality of life, as it were. So that definitely, that's a big no-no. So if they were caught doing that, they'd be in trouble. Is there anyone disagree with that?
I don't disagree, but in my head, this question is like relating to, say you need some physical work or plumbing or something like that done to the property, and obviously the council's contracted that out. The plumber wouldn't have to make reasonable adjustments to the client, or would they? I think that's what the question is sort of getting at, is would the, and maybe I'm just misreading contractors, but for me, and maybe it's because of the previous question about sort of the decent home standards, I've sort of linked the two. So my mistake, Tiff, if I'm completely barking up the wrong tree here. But in my head, it's around sort of like contractors like plumbers, electricians that are coming in and doing work that the council have ordered. They wouldn't be expected to make reasonable adjustments for that
No,
client, or would they?
they wouldn't. It gets a bit complicated because it raises the law of agency here. That if I ask you to do something and you do it so badly that something bad happens, am I liable? And the answer is yes, because you're my agent. You wouldn't have been there if it wasn't for me. And I think that sort of applies to a lot of council stuff. So they couldn't say, oh, the Equality Act doesn't apply because it's our contractor. But at the same time, the contractor themselves wouldn't be personally liable. And you couldn't say to the contractor, the Equality Act applies to you. But you could say to the council, why are you sending people round and telling them not to comply with your legal obligations? Does that make sense? Uh,
Yeah,
and I'll just
it
jump
does
on.
to me. I don't know if that is Tiff's question, but that's my
No,
interpretation. So apologies, Tiff, if I've just completely like
so that
twisted
was
your question.
that one. Hang on, did we, maybe I missed this. I think I should have put this at the end. So they've got where the question we had before was this one. We got about the country and requested, and it should have then gone on reasonable adjustments to be made. Who's liable if reasonable adjustments are not agreed, please? And the answer is, I think, the council, for the reasons I said before, because the councils are the ones who are under the duty. But then again, if this is where it gets starts getting a bit sort of waffly, but if the contractor did something and the tenant or the occupier suffered as a result, then they could be directly liable themselves because they should have known. But generally, if it was just a breach of the Equalities Act, then the council would be the only one who's liable because the contractor isn't subject to that. And I think got one more. We know we've had that one. Sorry. So then we've got cheese face. It may be annoying, but when you've had them 10+ years, you just can't get rid. Is that the contractors or the? I'm not quite sure of that one, but yeah, it's annoying. So
I think that's lions. I think Cheeseface has just got a garden full of lions and had them 10 years.
and iguanas, yeah, yeah. But so yes, so the yeah, it is the external contractors would be not subject. I think I've probably answered that one now, hopefully, and Shannon's done so as well. So I think that is everything for tonight, and I hope that was helpful, and it was useful, interesting for me, and these things are hopefully it's getting a bit more of a structure to it. Because I'm thinking ideally in time these videos will be structured enough that I could edit them and there'll be a little section on this and a little section on that rather than just us kicking the breeze. But I hope it's interesting anyway for everybody who was listening. Thank you all for taking part. And I'm afraid I won't be taking part in Mike's video on Thursday, but I'm sure that anyone who's watching this is probably aware of Mike's video before mine because you get a lot more people on there, a lot more questions. But I'll be back next Monday and next Thursday. So see you all then, hopefully. So that's the end for tonight. Bye bye.